Hello and welcome. Just letting people in from the waiting room. Give us a moment. We're about to get started with today's webinar. Okay, welcome. So today's webinar topic is committed intimate relationships in Washington State. And I'm going to be joined here in just a moment by Michelle Dellino from Dellino Family Law Group. Oh, there she is. And I'm going to go quickly here to introduce myself and then turn it over to Michelle so we can start delivering some great information to you and hopefully get some questions answered. My name's Melissa Rosenberg, and I am actually a therapist here in Seattle, and I specialize in working with clients who are dealing with different stages of the divorce and separation process. I work with clients who are ambivalent about their relationship and trying to determine whether moving forward with divorce or separation might be the healthiest path, or whether relationship repair is possible. I work with clients who are in their challenging, emotionally challenging family law case and working toward divorce. And I also work with clients on the other end who are picking up the pieces and navigating their next chapter. But today I'm here as a moderator for this webinar. And the way that it's going to work is I'm going to turn it over to Michelle in a moment. She'll introduce herself and she'll begin to talk about committed intimate relationships in Washington State and really deliver a lot of great foundational information about that topic. As we go, if you have questions, we'd like to be able to try and answer those for you. The way to ask them is to put those questions into the chat. The chat is set up here so that you can only chat with me. So anything that you send is only going to come to me. And I will then pitch those questions to Michelle. We'll try to answer as many of them as we can. It's important that I tell you that if you ask really specific questions about your case with too much detail, we're not going to be able to answer those. It's going to be a little bit more general information that we can attend to today. And so, we'll do our best to try to answer as many as we can. So with that, I think I'll go ahead and turn it over to Michelle, but we appreciate your time and we look forward to hopefully having you leave here with more information than you came with. Thanks.
Thanks, Melissa. Hi, I'm Michelle Dellino. I am the owner and founding attorney of Dellino Family Law Group. We are a family law firm with offices in Seattle and Bellevue. We help clients all over Washington State, and we have a full team. We have 15 attorneys and a full support staff. So what that means is there's always somebody here who has probably seen a situation like yours. So I've been practicing family law for 16 years and have seen pretty much everything on my end that there is to see. Committed intimate relationships is our topic for the day. Committed intimate relationships is an area of Washington law that is pretty unique to Washington. It's not really the same. It makes you realize that living together with someone in Washington is very different than living with someone in California. So we're going to talk a little bit about that today. Maybe it's a situation you're in, maybe it's a situation you've just heard about and you want more information. So what I'm going to do is talk to you about what is it? What does it mean? How do you determine, if you're in one? What are the rights that are attached with one? And what are also ways to protect yourself in a situation like this? Because you might get to the end of it and think, oh my gosh, I didn't realize this was a thing. I didn't realize that I either had property rights or that the person I'm living with has property rights. And you might be wondering what to do about that. So we're going to get to all of that. What I will do, Melissa mentioned asking questions. Definitely want to answer your questions. I think it's really valuable. If people ask questions, because when you do that, other people that are here, that are listening, there's a number of people on the webinar, even though you can't see them, they're here, and people will watch this later, and you really help contribute to the discussion as well as getting your own questions answered. So first thing I got to tell you is that I am an attorney, but I am not your attorney. So nothing that I say today forms an attorney-client relationship between us. Nothing that I say today should be taken as legal advice. It's really just general information. So if you send a question to Melissa that asks really fact-specific stuff and asks for really fact-specific analysis, we will try to maybe just pull out part of it, but I'm not going to be able to answer really detailed fact-specific questions. If you have those kinds of questions, you should really do a consultation. It doesn't have to be with me. It could be with any attorney here, or it could be with any law firm with somebody that knows about committed intimate relationships. So we'll do the best to get to your questions. And with that said, I'm going to talk about committed intimate relationships. So First of all, what is it? So you might hear committed intimate relationship. You might also hear CIR. Mostly, I mean, that's rolls off the tongue much easier. That's what we call them. They are CIR cases. What is that? It's a legal doctrine used to determine property division for unmarried couples who have lived together in a marriage-like relationship in Washington. What's a marriage-like relationship? We'll get to that. So Washington does not recognize what some places call common law marriage, and actually very few states do, but it does acknowledge CIRs as a way to ensure fair division of property when a stable marriage-like relationship ends. So what that means is if you've lived with somebody for a while, and we'll talk about how long and what that might look like, you may have property rights, either of you. Like they might have rights in your property, you might have rights in theirs. So we'll get into that a little bit. Legal recognition of committed intimate relationships. A committed intimate relationship is actually, if one is found, it's a legal finding by a court. You can say, hey, I'm in a committed intimate relationship, but that's not going to necessarily mean that property is divided. You actually have to take steps to do that. It's very similar to filing a divorce petition. Somebody files a petition to dissolve a committed intimate relationship and divide the assets. Other person responds and says, yes, I agree there was one. Let's divide the assets and work it out. Or no, I don't agree there was one, and no, I don't want to divide assets with you. So anyway, it's a lot like a divorce, the way that it starts. And a finding of whether a relationship actually qualifies as a committed intimate relationship is based on a multi-factor test. So I'm a lawyer, so I love a good multi-factor test. You might not know what that means, but what it means is there's a number of factors, okay? And you look at your situation, and then you look at these different factors, and you go, hey, does my situation fit into those factors? And it's not going to be the same in every situation. So your own individual situation needs careful consideration. But I'm going to tell you what the factors are. There was a case in 1995 called Connell versus Francisco, and that sets out these factors. So if you ever hear somebody mention the Connell factors, that's what they're talking about. They're talking about a case that was set forth to determine whether a committed intimate relationship exists. And you don't have to have all of them either. You don't have to have all of them. There's not any guidance from the court on which one's more important. But I mean, you probably want to have most of them, if not all of them. It gives you an idea, sort of if you're in that committed intimate relationship territory. The first one, I'm going to go over all 5, is continuous cohabitation. So couples have to have lived together continuously for a significant period of time. And this doesn't mean I have an apartment and my boyfriend has an apartment and we just stay with each other all the time. It means no, you continuously cohabitate, you share an address, you're living together. And it also doesn't mean, oh, we lived together for a year, then we separated for a year, then we got back together. It's continuous. And there's 2 things to know about committed intimate relationship continuity of cohabitation. One, it can be totally just in an unmarried relationship. You can never get married, and that's enough. 2, though, which is a common scenario, is where that unmarried period sort of tacks onto a marriage. Like you're living with someone, maybe you live together for 5 years, and then you get married. So you've got this committed intimate relationship period tacked on to the marriage, and that can actually extend the window of basically time that's up for property division. Or you never got married and you just have the time that you live together. So that's kind of the 2 different ways that can be determined. Other thing about it is how long. Well, I've had a lot of CIR cases over the years. A lot of attorneys don't, but we have actually handled a lot of them here. And CIR, if you're living with somebody for a year, you're probably not in a CIR yet because no one has really relied on the relationship long enough. It's hard enough to say if it's really committed yet. But when you get around that 2-year point, and there's not a magic number, but my experience is when you get around that 2-year point, you're entering potentially that time period for continuous cohabitation. Second thing is the duration of the relationship. And this is different than just living together. This is how long is the relationship. I had a case once, not that long ago, where parties lived together for quite a long time. I think it was like 16 years. And then they had kids later in the relationship. They had kids after maybe 4 or 5 years. And they were living together before, but they weren't really sharing money. They weren't really doing anything until they had the kids. So the court there found that when they had the first kid, that's really when the committed intimate relationship started. And it was really recognizing the length of the relationship and what portion of it was really committed. And kids doesn't necessarily make or break a committed intimate relationship case. There's plenty of these cases without kids. The third one is the purpose of the relationship. So The court's going to examine whether the relationship functioned like a marriage. Like, what was the purpose? Was the purpose to provide emotional and financial support and be there for each other as partners? If so, okay, then you're in that territory. If it was, we're roommates and maybe occasionally we have sex, or we had kid and then we started living in separate rooms and we really were just co-parenting and not in a real relationship, or our finances were totally separate and we were just companions, like, what is that purpose of that relationship? If it really is for emotional and financial support and to be a marriage-like relationship, that's really what the court's looking for. It's really about, is this a marriage-like relationship versus a casual relationship that might go on for a long time, or a friendship? So that's the third one. The fourth one is the pooling of resources. Now, this is always the one that people kind of get hung up on more than others. Pooling of resources and services for mutual benefit. So this means, did you share finances? Did you have joint accounts? Did you own property together? Did you, did you name each other and each other's insurance, things like that? You don't have to share accounts, though. It can also mean, did you do things like contribute to household expenses? Like, let's say, this is really common too. One person pays the mortgage from their account. Other person pays maybe like the utility and the Comcast and the cable from their account. So you guys were obviously pooling resources. Or you go, somebody goes to the grocery store and one person pays for most of it. The other person contributes something. You go on a vacation. Did you share resources? It's very easy to identify if you have a bunch of shared accounts, but that's not always the case. So sometimes we really have to look at the specifics of your situation. But the pooling of resources or services, did this is a common thing too. Did some person work for someone else's business for a number of years and not get paid? Or even, what did that look like? So anyway, pooling of resources and services. And then the last one is the intent. Now, we've talked about the duration, the purpose, the cohabitation, the resources, but what was the intent? Did you present yourselves as a committed couple and intended to function as a unit? If you have a committed intimate relationship, people know about it. So it can't be like, oh, I lived with this person for a number of years, but my family didn't even know they existed, and none of my friends knew, and it was like a secret. That's not like an intent. It's what the court calls holding yourself out as a couple. And people actually know that you were together, because if you were married, people would have known. So it's a marriage-like relationship. So those are the hallmarks. Before I move on to talking about the rights and property division, Melissa, do you have any questions you want me to hit really quickly?
I do have a couple questions, and I actually forgot to mention at the beginning, related to the questions. Yes, you can ask them in the chat, but there's also the Q&A option at the bottom of the screen. If you click the Q&A option, those questions do get broadcast to the group. So you can mark yourself in as an anonymous attendee, or you can have your name show up. That's your choice. But so you can ask me questions either in the Q&A or in the chat. And I do have a couple. One
Sure.
question is whether, when we're talking about when a CIR ends, could you use a text message as evidence of that?
Sure. Yeah, it kind of gets into a similar question that we have about divorces too. Like, what's the date of separation? When did it
Yeah.
end? Did it end when you texted somebody and said, hey, I no longer want to be in a relationship with you? Great. That could be when it ended. But if you then kept sleeping in the same bed with that person, being intimate with them and paying for things for them and going to therapy, then no one's going to care about your text message. Okay, because people can say that. But if you sent a text message and then things change from how they were before, it doesn't have to be in every way, but if things change, then that's going to be more persuasive. So it's really fact specific. But yeah, it can be an email or a text message, or it can be an action of somebody moving out. It can be a number of things.
Okay, thank you. And then the other question I have here has to do with property division. The question is about how coercive control would play into division of property, if at all. And what if a situation meets criteria for coercive control, but the attorney is not interested in pursuing it?
Hmm. Well, coercive, okay, this is a good time for me to tell everybody that what coercive control is, and
Yeah.
that coercive control is a form of domestic violence. Washington legislature acted to expand the definition of domestic violence to include coercive control, which is a systematic kind of pattern of behavior of controlling someone either through verbal abuse, financial control, anything that someone does systematically to make someone feel like their liberty is somehow restricted. And you're not going to get more money for that. So it doesn't mean that it's not a factor. It might be a reason to seek a domestic violence protection order or a restraining order in the context of the committed intimate relationship case. But it isn't going to mean that you're entitled to more of the assets. So Washington is a no-fault state when it comes to divorce and also to a CIR division. It's something that you're going to need to deal with, but it's not going to result in more resources for you necessarily.
And then the other question I had, which we're probably about to get into, is when we talk about the CIR, okay, so if it meets criteria for a CIR, what rights does this person have after cohabitating? Alimony, property division, what does that look like?
Yes, let's talk about it. So, okay, property division and committed intimate relationships. Let me tell you what you don't get. You get what you get in a marriage, but two things you don't get. You ask for alimony. Alimony is called spousal maintenance or spousal support in Washington. There is no spousal maintenance or spousal support that is associated with committed intimate relationship. You simply can't seek that relief. So here's a good example. You live together for 10 years. You're going to divide property. We'll talk about that in a minute. You're not going to get any maintenance at all. You live together I had a case, this was a few years ago now, but it was actually an 11-year relationship. They lived together for 10 years. They were married for 1, and then they got divorced. So most of the property division was from the committed intimate relationship, but there was no spousal maintenance because they were really married for 1 year. So no spousal maintenance, which is the Washington term for alimony. No. The other thing you don't get is attorney fees. And this is really, really important for you to know. So in Washington, attorney fees in a divorce can be awarded based on need and ability to pay. One party's got a need, other party has ability to pay. In a committed intimate relationship case, there is no need and ability to pay standard, and there's no ability and no authority for the court to actually award attorney fees. So what that means is you have to be able to fund the case on your own. You have to be able to fund it somehow. And what ends up happening a lot of times is one party has more resources than the other, and the party that doesn't have the resources can't seek fees from the person who has the ability to pay, and they don't have a way to fund their case, and then they don't get anything because they don't pursue it. And the return on investment, this is the thing. If there's really no assets that were acquired during the relationship, then it's probably not worth it. But in most cases where it's been a stable marriage-like relationship, there's probably a home, there's probably a 401k, there's probably something that's considerable enough and makes it worth it for you to get legal representation. But you cannot get attorney fees from the other party. You cannot get spousal maintenance. So what can you get? You can get a community-like share of the assets and debts. So what does that mean? Okay. The best way to put it is this. What is community property? You've probably heard that term before. Washington, as what everybody likes to say, is a community property state. Totally true. What does that mean? It means everything that was acquired during that period, whether it's an asset or a debt, is community-like in character. And I'll say community-like instead of community because it's not a marriage, so it's community-like. Same difference though, okay? So let's say, give you real-world examples is the best way to explain this. I move in with somebody, we're living together, we're in a relationship. Let's say we're in a relationship. I like to use round numbers. Let's say we're in a relationship for 15 years. That's a good number. And let's say I had a 401k when I got into the relationship. I'd only been contributing to it for a year. But then I contributed to this 401k for 15 years during the relationship, right? And let's say that my partner had their own and they did as well. So partner's name isn't on my 401k. My name's not on theirs, but we acquired funds that were earned during the relationship. So that portion of the 401k is up for division. If I earned $1 million over 15 years in my 401k, somebody else has got an interest in that, probably pretty close to 50%, maybe more, maybe less, but it's there. So that's important for you to know. Community-like means name on title is not determinative who owns the property. So you could be in a relationship with somebody for a number of years and their name is on, let's say they earn money and their name is on a bank account and they're putting money that they earn while they're with you in that account. You potentially have an interest in the money that was earned during the relationship, even though your name is not on it. So pretty much it's any asset, anything at all that's acquired during that time, you potentially have an interest in, or they have an interest in yours, right? And there are exceptions to that. If you have something like a business or you have a piece of property or something that was acquired before the relationship, before you were living with them, That's your separate property. And if you're earning money from that during the relationship, if you have a rental house and somebody's giving you rent every month, that's from your separate property house. That's different. If you bought that house during the relationship and you used money to put down on that house that you earned during the relationship, that's probably a community-like house. So you get into these fact-specific scenarios. But basically what it means is you take the pie, you put everything in it, you take anything out that's separate, and then you divide it up. So that's what you're entitled to. You're entitled to asset and debt division of community-like property the same way you would be in a marriage. And that's a pretty big deal. Other states don't have that. And a lot of people don't know, and they think, well, I didn't get married for a reason. I didn't want to have to worry about that. Yeah, but you shared your life with someone in a marriage-like relationship, and those rights attach in Washington. So that's really important for you to know. And then the second thing I will say before I move on is, how is it divided? Well, Washington is a community property state, but not a 50-50 state. If you've ever watched any of my webinars or come to my meetups or heard me talk or consulted with me, you know I'm going to tell you that right away. We are not a 50-50 state. Everybody thinks community means I get half and you get half. Wrong. No, not true. So if you're in some states, that's the case. Like California is a very big state. It's close to us. We have some similar rules to them, but they are 50-50. Nobody cares how much money you're making or how long you were together. Everything that is community is going to go 50-50. They also don't have CIRs, by the way. Here, that's not what's going to happen. Maybe it's going to go 50-50, but the court is going to look at two things. They're going to look at the length of the relationship of the CIR, and they're going to look at the financial situation of the parties when you're breaking up. Like, is somebody working and they've stayed home the whole time? Is somebody been the primary breadwinner? Does somebody, basically stayed home and watched kids, or someone just worked a lot lower income job and helped support the other person? Like, what's the deal there? A Washington court wants to know more about your marriage. And typically the financially disadvantaged spouse, the person that makes less, might take more of the community-like property because they're not going to recover as quickly from the breakup and the division of assets as the other person is. So it could be 55-45, could be 60-40, could be 52-48, or it could be 50-50. It's going to depend on your situation. But the property can be divided. If a CIR is found, it will be divided. And like I said, separate property stays with the original owner. So that's property before the relationship. That's also gifts and inheritance, as long as they're kept separate and you keep them separate. Gifts and inheritance by operation of law stay separate property. So that's basically what you get. And then I'll say, before I take more questions, and I'll go into some detail as well, but why does it matter? So who cares about any of this? Well, it matters because CIR ruling affects property division. It doesn't give you legal rights to spousal benefits, though. So it doesn't give you rights to inheritance that you would get under Washington estate law. It doesn't give you rights to it doesn't give you rights to another party's social security after a certain period of time in marriage. It doesn't give you any of those things, but it does could give you a considerable amount of property, or you could have exposure that you could be paying a considerable amount of property if you are the breadwinner. So before I talk a little bit more, Melissa, is there anything else that you want to?
Yeah, got a bunch of questions. I think this is a really important one, is relates to kind of how to protect yourself, right? So is it possible to be in a CIR, living together, but not have legal ties if you split? How do we make sure what's mine is mine and what's theirs is theirs? Is it as simple as keeping all accounts separate? Does splitting rent or mortgage mess that up? Do you get a prenup
Yes, this is a great
situation?
question. This is the next thing I was going to talk about. It
Good.
is not enough to have separate accounts. It is not enough to say we're going to contribute to this equally. No, I mean, if anything, you're pooling resources. Doesn't matter. Name on title doesn't matter. You need a cohabitation agreement. That is what you need. And I'm going to talk about proving or disproving a CIR, but I want to talk about protecting your assets in a CIR. And you asked a great question, because there are a number of options. The number one thing you need to do is have a cohabitation agreement created. Cohabitation agreement is a legally binding document, kind of like a prenup. There's prenups, postnups, and cohab agreements. Prenups are in contemplation of marriage. You don't need a prenup, because if you don't get married, the agreement's no good. You don't want a postnup, because a postnup is only after you've already been married, determining property rights. You want a cohabitation agreement. So that's going to outline how assets and debts will be handled during and after the relationship. That's what you need. And honestly, it's not that big of a deal to do. It's well worth it. I've done cohabitation agreements for many, many people, and it has saved them, I mean, literally tens of thousands of dollars. You could have have a committed intimate relationship case, the average cost of that for each party is going to be between $25,000 and $30,000. When that is not a case, that's a case that's not going to trial. So, or you could spend a couple $1,000s and get an agreement done, and hopefully you never need it. But if you do, it's going to make it very clear what's mine is mine, what's yours is yours, if that's what you want. A very common agreement that I like to do for people is a name on title agreement. What's in my name is mine, what's in your name is yours. That's it. If we put both of our names on something, that's intentionally created community-like property, and then we determine how that's going to be divided in the agreement. That's a very simple one, and there's a lot of other things that go along with that, but that's one way to do it. There's other ways to do it as well, but it's really, really important for you to know an agreement is important. Elements of the cohabitation agreement. One, you want to define separate property and what is shared property. You have to define that. You have to have an asset and debt disclosure that defines it for the agreement to be binding. Two, you want to clarify debt responsibility, because community character doesn't just apply to assets, it also applies to debts. If someone takes out a ton of debt during that relationship, you could potentially be responsible for that. So it's a really good idea to be specific about debt definition. Then also outlining property division, not just what we have now, but upon separation. How is that jointly owned property going to be divided? Next, address home ownership or rent agreements. If one partner owns the home, you want to specify what the rights are of the others. And there's Washington law on what happens if you have a home and somebody lives in it and they give you some money towards like the mortgage or whatever. Well, that's typically termed reasonable rent. You got the benefit of living there. You're not gaining an ownership interest, but it's a very important to clearly define that so it doesn't become an issue. If a property is purchased during the relationship, you want to be clear on whose it is. Is it community? Where'd the down payment come from? You want to go through defining all of the real property that's already owned and that could be purchased during the relationship. And then sometimes, you don't always want to do this, but I recommend it, agreeing on financial contribution, defining who pays for what. If you're going to have one account that's for household expenses, are both parties required to put money in? Is it optional? What does that look like? And then also to a waive, basically a limit on claims. If you have specific property you don't want to be divided, you want to be clear about that, and that's usually separate property. So making an agreement, anybody can make an agreement, but making it enforceable is another thing. There's a test in Washington that really applies to prenuptial, postnuptial agreements, and it's been applied to cohabitation agreements as well. And it really is a test for validity. You each want to have an attorney review it. You want to have independent counsel. One person drafts it, the other attorney reviews it. You want to have it negotiated for. You want to have that full disclosure of debts and assets. You want to essentially make sure too that nobody is coerced or forced into signing it and said, threatened, if you don't, I'm going to do something to you. So there's a number of factors, but basically you want to have someone draft it for you and you want it to be done right. And it's really, I think of it like car insurance. Some people are like, oh, why should I get an agreement? That's just betting on the relationship to fail. Well, no, you don't drive around with liability insurance because you're planning on slamming into someone. You do it so it doesn't financially decimate you if it happens. And if your agreement is to end, if your relationship is to end, really a cohabitation agreement is a sign of love and trust to one another that says we're going to determine how this is going to go, not like the state of Washington. And we're not going to spend a bunch of money tearing each other apart if it does. So highly recommend a cohabitation agreement. There are other things I can talk about as well, but I'm sure there are other questions before I do.
Yeah, as you're talking about cohab agreements, is there anything related to the statute of limitations related to all of that?
Not to cohabitation agreements, but there is to committed intimate relationships.
Okay.
So you have 3 years from the alleged end of a committed intimate relationship to file a petition for division of assets. So let's say okay, let's say this is March of 2025. If you were living with someone and that relationship ended in February of 2022, you would be past the statute of limitations and it would be too late and you couldn't bring your claim. If you break up with someone now, you have 3 years to bring it. But if you don't, I'm going to tell you this, if you don't bring it soon and right away, it could be a lot harder later. And then you're going back and trying to get financials from later. And then accounts are going to have more post-separation and community character, and you're going to need to get valuations. It makes the case a lot more complicated and difficult. So if your relationship ends and you think you have rights and you want to do something, don't wait a couple of years. It's going to hurt your case and it's going to cost you more money.
Okay. And then just a little bit ago, they said the coercion Michelle just mentioned is exactly what I was referring to related to the coercive control question earlier. If one is coercing the other during division of property, is there anything the other person can do?
You get an attorney.
Yeah.
I mean, you shouldn't be negotiating a property division with someone because you don't know what's right, and it's easy for
Yeah.
someone to be like, "Oh, they're forcing me." I was mainly talking about like entering into an agreement. An agreement's not valid if you don't have it. But no,
Yeah.
someone shouldn't be coercing you about property division or threatening you or anything like that. You need someone to negotiate for you, because they're probably doing that because they know they have exposure and they don't want to give you anything. So don't
Yeah.
let them push you around.
Yeah.
That's yeah. And that's
There's a bunch of questions, but I'll just ask a couple of more and then maybe you can talk about a few other things. Um, okay, earlier when we were talking about kind of the intention of the relationship and how we define what a CIR is, what sorts of documentation or information would prove the intent of the relationship?
Well, documentation as far as intent is a tricky thing. But there are some things that are number one, do you have shared bank accounts? That's documentation. Number two, do you have wills naming each other as partial beneficiaries or full beneficiaries? Do you have powers of attorney giving each other authority to make decisions? Did you put this person on your medical insurance at some point? Did you register as domestic partners? That's less likely now. But you can't register as state domestic partners, but cities still sometimes have registries, things like that. So bank accounts, insurance designations, last will and testament, but those things aren't the only way. There can be other things. I could have added you on to my T-Bumble account and we share a phone account. There's any number of things that are helpful, but those are kind of some big things. So I hope that helps.
Okay. Do you
Yeah.
want to take a few more or?
I'll take a few more. Actually, why don't I talk about a few more things that I think are options to protect property? The cohab agreement is number one, though. If you don't have that, then none of these other things don't really matter that much. But I will talk about them, and then I'll take questions. That's probably what we should do. So, cohabitation agreement, we talked about that. Get one if you don't have one. Consult with somebody to determine what that looks like. Number two, oh, and I can't tell you this enough. Go to a family law attorney. And it doesn't have to be me. I'm not saying this for me. I'm saying any family law attorney. Go to a family law attorney. Don't go to a general practice attorney. Don't go to a real estate attorney. Don't go to a trust and estates attorney. Go to somebody that actually understands family law. Why? Because every time I get an agreement, like that's from somebody who's not a family law attorney that doesn't understand these issues and doesn't understand community property, they're missing glaring things in the agreement. The agreement is it's really flawed. And then I got to go through and I've got to fix it. And that's going to cost you more time and money. Or you're going to get an attorney on the other side who doesn't know how to go through and fix it. And then when you break up, it's going to have significant things that it's missing or that aren't valid. So get a family law attorney because we are the ones that know what happens and commit an intimate relationship when it breaks up. Just like I can draft a real estate contract, sure. I know how to do it. I can draft a contract for anything. But I shouldn't be doing it because I don't speak that language and live and breathe that every day. So I'm probably going to miss things, right? Go to somebody that knows. I can't stress that enough. Don't go to your family's dad's attorney who's always handled their stuff for 20 years. Go to somebody that knows this kind of law. So the other things I was going to mention, estate plans. Estate plans are so critical for unmarried couples. If you don't want to get married, don't. I mean, I'm a big believer. Don't get married if you don't want to. And if you do get married, you should get a prenup. But if you're going to stay just in a committed relationship, it's going to be unmarried, you don't get the same rights that a married person would get. You're not going to be that first call to make medical decisions for your partner. If you die, your partner has basically no inheritance rights the way that they would if they were married. Even if unmarried people die, they should have an estate plan too. But there are inheritance rights for married people to a certain degree. There's nothing for committed intimate relationship cases. And then you have to go and bring a claim against the estate, and it's really ugly and really messy and really difficult. And there's no rights. So you want to get a basic will. You want an estate planning package. And I recommend a will, a durable power of attorney, and a healthcare directive and power of attorney. Those three things are very basic. They can be done and they can give your partner some rights, or they can give you some rights to make decisions, to stay living in your house a little bit longer if it's your house, any number of things, but you need an estate planning package. Then order of operations, I think your cohabitation agreement, estate planning package. And then the third thing that you should do is clearly define the ownership of your homes, your vehicles, and significant assets that are yours from before the relationship. What I mean by that is all right, I own a home and now you're living with me and we've been living together for a couple of years and I'm going to refinance it because, oh my gosh, these rates have come down and my credit's not that good. And so I'm going to ask if you'll be on the loan with me because I'll get a better deal and you're living here anyway. And it was my house before. And now I've put you on title and now you're going to start paying towards it. I could actually change the character of that house by putting you on it because I wanted your credit to help me get a better rate. Don't do things like that. And that kind of goes back to getting a cohabitation agreement too, and really understanding how to handle those situations. But be careful with changing title on things that were yours beforehand. Get an agreement, get an estate plan, be careful about titling things. Okay, I'll take some more questions.
Okay, well, let's see, earlier you were talking about length of the relationship, whether, and whether they're married and or pre-marriage and the CIR stage of it. If a marriage only lasts for 8 months, how does that factor in at all? Does it matter?
Matter. I mean, if you were living together beforehand, that's what matters. No one cares. Like if you were married, the fact that you did get married actually can strengthen your claim for a CIR because it can be like, well, obviously they were serious before they got married, so it was probably committed intimate relationship, right? It doesn't matter if your marriage didn't last that long.
Yeah.
It's really about if you were only living together for 8 months, that's not long enough for a CIR. But if you lived together for maybe 3 or 4 years and then you got married, then you got a CIR probably, maybe.
Yeah. Um, and similar, or this kind of relates to what you were just talking about. What would happen if it was a CIR, but you didn't have a will and the partner on the deed of the house that you're living in died?
Probably in a bad spot.
Yeah.
You're probably not getting anything.
Yeah.
Yeah. And that unfortunately that happens a lot.
Yeah.
Yeah. That's why I'm watching this though. So you know to get a cohab agreement and you know to get an estate plan. Like we get calls a lot where it's a sad situation because somebody's like, oh, my partner is really sick or whatever, and it's too late to make a will. You have to have capacity to make a will. If somebody, doesn't have the capacity and isn't with it or they're in the hospital, it's probably too late. So do that stuff now while you are healthy and able to make decisions.
Okay, if personal assets are being put into an LLC that your name is not on, does the other partner still get a portion of those potentially?
Yeah. I
Yeah.
mean, if the assets were earned during the relationship, potentially, yeah.
Yeah.
You could have an ownership interest in what's in the LLC. An LLC isn't enough to um I was gonna say to change that, you know?
Mhm, mhm. Okay, let's see. If new structure was built on property that he owns during the relationship, are you entitled to potentially half of or part of that value?
Say that again?
Yeah, and if a new structure was built on property that one partner owns during the relationship, would the other person be possibly entitled to half of I guess, the new value?
No, I mean, not if it's not their property. If
Yeah.
they paid for the structure or their money went towards the structure or money that was earned during the relationship by one party went towards the structure, they could have what's known as like a community like lien on part of it, but it isn't going to change the character. There's character of property. This is a good time to talk about this. The character of property is established at the time it's acquired. So if I buy a home and or a piece of land in this case, and my name's on it, and I don't change that. That's mine. Doesn't matter if you come live there, doesn't matter if you pay rent or whatever, doesn't matter. It's mine. The only way I can change it is two ways. One, I can transmute it. And this it requires two things. I can change the title. I can add your name to it, whether it's a piece of property, a bank account, whatever. I can transmute it from separate to community-like property. And I show an intent to do it, to basically make it community-like. So the intent piece gets muddled, but you have to have a writing that transmutes it, and you have to have an intent to change the character of it. The other way is commingling it. If I inherited $100,000 and it was mine and it's in my account, and then I put it in our joint account and we started spending money out of there and putting other money in there, and then you can't really tell what was what anymore. I've commingled it, I've lost it, it's probably gone. So commingling and transmutation are the ways that you change the character of the property. Otherwise, the character of the property is established at the time it's acquired.
Yeah, there's a handful of questions that are related to kind of rights to the home. If I owned my home, but the partner pays rent, does that give them rights to the home in the CIR
No,
context?
it doesn't.
Yeah.
It doesn't. No, if they were making like major payments to help you pay off the mortgage or something, but if they're just paying a reasonable amount of money to live there, no, because they would have to pay to live somewhere. So
Yeah.
it basically is like reasonable rent. They're not getting like community lien on the house. However, a common scenario is somebody lives there and they pay out of their property to put a deck on the back, right? Or they pay, I don't know, I paid 25,000 out of my savings to put towards the kitchen we were remodeling or whatever. That doesn't change the character of the property, but you might have a lien on an interest for the increase for part of an increase in value that's attributed to what you paid for. So that is another calculation that comes into play potentially.
Okay. Yeah, the other question about it was, what if my home is in a trust, but
If your
doesn't,
house is in a trust and it was in a trust beforehand, then you're probably okay.
yeah,
But it's the same thing. If you bought a house and you just stick it in a trust during the relationship, that doesn't change anything. It still could be community like.
yeah, yeah. Okay, let's see. A couple other questions. We're powering through them pretty well. Are the assets that we're talking about in division of assets valued by the amount spent on them or their value at the end of the relationship?
I don't know what you mean by amount spent on them. So I'll just tell you, like, if you own, if you have an account, let's just say, I'll take a couple common accounts. Let's take a savings account. If you have a savings account, it's the value of the savings account. It's not how much you put in, it's the gains and losses as well. So gains and losses are attributable to the community. So sometimes you'll have mixed character accounts though. Let's say I have a taxable account and I was putting money into it, or like that 401k I was talking about. I'm putting money into it for a couple of years and then I get in a relationship and then I'm contributing money during the relationship. Then you have a mixed character account, and then you'll need to have a professional evaluation done to determine what are the gains and losses on the separate and community portion to know what is attributable to both. It's not just the money you put in, it's the gains and losses as well.
Yeah, like if it's a house, we're talking
Oh, and
about
and a
sort of
house, yeah, no, it's not just what
yeah,
you put in, it's what the house is worth.
yeah.
But there are also a lot of rules around the down payment. If the down payment is separate property and only one name's on title, then it's going to be a separate property home. If
Mhm.
both parties contributed towards the down payment, or if the down payment came from money that was potentially community-like and earned during the relationship, then it's potentially community-like. So these are scenarios you're really going to want to talk to somebody about. Other thing too is this is why you want a cohabitation agreement if you don't have one, to be very clear about defining what's what.
And you said earlier that there's no attorney fees related or paid
You
for
can't be
anything.
awarded attorney fees, no, based on the inability to pay. If someone acts in like really bad faith and does something and like won't give you access to something that they should or acts in bad faith, you can always seek attorney fees for bad faith, but they're not very commonly awarded and most people don't do something that's so bad to get fees awarded. Most common way for fees to be awarded is need an ability to pay in a divorce, and that doesn't apply in committed intimate relationships. You got to be prepared to fund the case on your own.
Okay. Um, an interesting question. Somebody's asking, what if a CIR partner dies and we have minor kids together? Does that give the children property rights or?
No, the children would be the legal heirs.
Yeah.
So like, and it depends on if that person has an estate plan. It's really important for you, especially if you have kids, to do an estate plan. Because here's the thing. Your kids could get that money, but if your kids are minors, then there will need to be a trustee for that money. Number one, will that be you? I don't know. It could be somebody else, like you and your partner really will want to make sure that you talk about that. So.
Okay. And then another question is about, whatever the outcome is of a CIR case, are you able to appeal an outcome?
Um, Yeah, it depends on the outcome, how it's reached. If you reach an agreement and you agree to it, then no, that's not appealable. You agreed to it. You might have buyer's remorse later, but you agreed to it. You signed a settlement agreement. You signed final orders. If you go to a trial and you don't like the outcome at trial, you have 30 days to file a notice of appeal with the Court of Appeals and seek an appeal. However, an appeal in a divorce or a committed intimate relationship in any family law issue is very difficult and an uphill battle. And you shouldn't do it unless one of two things applies. One, there's a clear error of law. Like you really believe there's an error of law, a black letter law. And you'll know because an attorney will tell you, and an appellate attorney will tell you there's a clear error of law here. Or two, you really believe that the trial court abused their discretion. However, the trial court, whoever heard the case, is going to be given a high level of deference because they heard the case. So abuse of discretion is almost never a reason to overturn it. Or three, I guess, it's an unsettled area of law and there's no law on whatever your legal issue is. But I would not spend money on a family law appeal without really getting a case evaluation by an appellate attorney.
Mhm. Okay. And then this is a general question, I guess, related to the separation process. If you're coming up with a counteroffer, does the client initiate action or does the attorney initiate action? Apparently, they're saying that the opposing party is accusing the client of not responding, and then the client's trying to figure out if they're supposed to respond or their attorney's supposed to respond.
He is supposed to respond. If you
Yeah,
don't have an attorney that's responsive, you should get a different attorney.
yeah, that's a
Or
good.
it might be a situation where your attorney doesn't have all the information they need to respond yet, and the other party is being ridiculous. So that could be the case too.
Yeah. Um, all right. More about division of assets. If one CIR partner has been saving their money and the other partner is getting loans and accruing debt, how will the saved money and the debts be divided? You know, how, like you said, it kind of goes into a pot. We figure it all out.
And then asset division's figured out.
Yeah.
So yeah,
Yeah.
that's not
Yeah.
uncommon. One person pays for a lot of things, the other person saves a lot of money, and that's equitable. It's equitable for that money that was saved to be divided if there is a CIR. So
Yeah.
yeah, I will say this, like just to summarize, because we're going to get near the end here before I take a few last questions. Think about it like this. You need to determine, am I in a situation like this? Am I thinking about getting in a situation like this? If so, think about the things that we talked about. Are you pooling resources? What's the intent? Think about those kinds of things. What's the length of cohabitation? Are you holding yourself out as a couple? Do people know about it? Is it likely a CIR? You want to think about that. If you're already in one, it's not too late to get a cohabitation agreement. And it's not a bad thing to live with somebody. It's just a bad thing if it ends and it's a mess and you have to spend money and and you have to fight about this. So you can easily deal with that by getting a cohabitation agreement and an estate plan in place. It's highly recommended. That's really what you should do. And the other thing to know too is, you know, having these conversations early on in a relationship forces you to talk about money and to determine maybe what your compatibility is on money. Because as a divorce attorney, we see relationships end all the time. And the one of the top three things I would say is money and how people handle it and deal with it. And if you get an agreement in place, you have to have those conversations. So you're actually kind of ahead of the ball and you're probably going to have better communication. And it sometimes reduces the likelihood that the relationship will blow up over money. So I hope that helps.
Yeah.
I could take a couple more before we wrap up.
Okay. Well, we kind of just talked about, we didn't talk too much detail about how debt is factored in. But, when we talk about division of assets in a CIR situation, are you also taking on the other party's debts?
Mm-hmm. Yeah, that's why I said like defining debts in a cohab agreement is really important. Because yeah, like let's say you're together and someone takes out a loan and is paying for things for it. Maybe you didn't know that they were, or they're contributing to the household bills and you thought it was their income and it was a loan. You can be responsible for that. Name on title doesn't control. So assets and debts can be community-like.
Yeah, that's really important. Okay, and then another question here regarding placing assets into a trust. Would you recommend to file a CIR before ending the relationship? Do you do that? Is there something about, like, I guess, creating something that declares something an committed intimate relationship before you end the relationship? I'm not sure if I'm totally understanding the question.
No, you don't file for division of assets until like the relationship's
Yeah.
over.
Yeah, I
When
mean
you
the
want to
the,
declare
the committed
something,
intimate relationship is the filing. You're calling, yeah, yeah,
if you want to define your rights or say what something is or isn't, then you need to do that in a cohabitation agreement.
yeah,
That's what people do beforehand. But yeah, you file the petition after you've broken up. That can be confusing. So that might be what you're asking.
yeah. I think we've covered most all the questions
We
here.
have. We had a lot of great
Got a
questions.
lot of questions. That's great.
This is a pretty narrow area of law. It is, what is a committed intimate relationship? What are the rights? How's the property divided? So what rights don't you have? You can't get maintenance. You can't get fees. You can get a right to property, but it depends on if there really is a committed intimate relationship. So there's a lot of variables. And then we talked about what you can do to protect yourself. You can get a cohabitation agreement. You can be careful about not changing title on separate property. You can get an estate plan. Those are things that you should do. So I really hope this was helpful. You guys had a lot of great questions today. Melissa has put up some information here if you want to contact us. This will also be available on our YouTube library. You can link to our YouTube library from our website, which is dellinolaw.com, under the news and resources section. This will be up there eventually. There's another committed intimate relationship webinar from a while back, so probably has some of the same information, some new information. But thanks for coming. Thanks for bringing your questions, and hopefully we'll see you next time. We do have, let's see, next week, is it next week? We do have the meetup group next week. The last Wednesday of the month, we do a meetup group where you can log on. It's virtual every month, except for once a quarter. It's in person. It was in person last month, so this one will be virtual. And you can ask questions, not just about committed intimate relationships, really anything. And there's usually a good number of people there, so that's a really good opportunity for you to get more information. You can also, like I said, go to our YouTube library. This will be there if you missed anything that I said, you want to listen to it again, or you want to see the other videos that are there. You can also ask me a question on TikTok if you want. Sometimes I answer questions there in my copious amounts of free time. And that's it. But again, if you have specific questions about your situation, I highly recommend that you talk to a family law attorney about it and get an analysis, because you could either have a lot of exposure or you could have a lot of rights. Either way. So it's good for you to know. Thanks a lot. Take care and have a good day.
Thanks, everyone. Thanks for coming. I'll leave this contact slide up here for just a few moments. Please do reach out to Michelle's firm. If anyone's interested in counseling services, feel free to reach out to me. And yeah, we hope to see you again in the future. Thank you. Take care.